Good morning. It is 9 o'clock. This is Sheila Apodaca. I am the clerk for the Oil Conservation Commission. Our meeting is going to be starting a little bit late this morning. We have a new director and a new chair of the commission that will be attending the meeting today, but he did have a scheduling conflict. So he's going to log on as soon as he can, but we will be running just a little bit late. Mic test? That fixed it? Oh, wait, let's see. Good morning, Mr. Chang. We see you. We're online.
Great. Good morning. Sorry, I'm late. Are my other commissioners? I see Dr. Mpoma. Hello, Dr. Mpoma. Is Commissioner Bloom in the room with us, or online with us? Sheila?
He is, let me see, I'm looking for him.
Okay.
Hi, Mr. Chair. I thought we might be a little bit longer. I checked in with Sheila. I'll be ready to go in about 2 or 3 minutes here. Okay.
Oh, okay. Sorry.
Yeah. Be there momentarily.
We can wait. No worries.
Good morning, Chair.
Good morning. Thank you, everybody, for your patience. This is my second day with the Oil Conservation Division, so it was a bit of a surprise to me. We'd be doing this morning. So, all right.
Also, our court reporter lost her internet service. So
Okay.
we're not going to have a court reporter on, but I am recording the hearing, which they can transcribe. She's going to log on as soon as she gets service back, but we may be starting out without a court reporter.
Got it. Okay. No problem.
All right, Mr. Chair. Congratulations on your new position. Look forward to working
Thank you
with
very much.
And I'm ready to start whenever you are, sir.
All right. Dr. Mpoma, are you ready
Yeah,
as well?
I'm good. Yes.
All right. Sheila, would you like to start us? So I guess we'll call this meeting to order. Sheila, would you like to start the roll call?
Yes. Okay. Can we have a roll call of the commissioners, starting with Dr. Mpoma?
Present.
Okay. Mr. Bloom?
Present.
And Chair Chang?
Present.
Okay. All right. We have a full quorum.
Next on the agenda, I see the approval of today's agenda. Any issues or questions? Discussion?
No, Mr. Chair, I would move to approve the agenda.
Thank you. So moved.
And I second.
Great. We have a mover and a second. All in favor say aye.
Aye.
Perfect. Nays? Without objection. Meeting minutes from May 15th and May 19th through the 21st of 2025. Any discussion on that?
Yes, Mr. Chair, I was not the designee of the Commissioner of Public Lands for that period. So as I've done in the past, I will abstain from voting for those minutes as I'm not familiar with the proceedings.
You know, so I would be held to that same, so I would have that same problem. And then I don't know that we would have a quorum to be able to approve if we both abstained. So I'm actually going to refer this to our commission counsel. My understanding is that generally speaking, even when members are swapping out, as long as we are comfortable with the veracity or the trustworthiness of the meeting minutes, we can approve, but I will defer to commission counsel to advise on that. Is commission counsel with us?
This is Zach Chandler. Yes, in this circumstance, I think that is the proper course, that if you can rely on the representation of the commissioner that was present, that the meeting minutes are accurate for the purposes of having a vote. I'd advise that you do not have to abstain in this fact pattern.
Okay. In the interest of, are you comfortable with that, Commissioner Bloom, or would you still prefer to abstain?
No, I'm comfortable with Mr. Chandler's thoughts there.
Great. Okay. Any further discussion, any changes, any amendments or anything like that, Dr. Mpoma or Commissioner Bloom?
Yeah, so I would like to draw Mr. Bloom's attention to May 15th minutes, which you were present for that, but certainly not the May 19th. So I've reviewed the May 19th to 21st minutes. Everything is all good. To me, I do not have any additions to that.
Great. So no amendments, no changes to the minutes?
Yes,
Mr.
sir.
Chair, I'm sorry.
Yes, sir.
I would, yeah, let me start over there. Mr. Chair, I would prefer to take these, vote on these minutes separately. And with respect to the May 15th minutes, I just had one minor change there.
Sure.
Let's see, under action, third paragraph, second sentence, the word provide should be provided.
Okay.
And
Sheila, will you be able to make
would-
that change? So, sorry, I think I talked over somebody there.
Mr. Chair, I would move to approve the May 15th commission meetings, making the change that the word provide as identified be changed to provided.
So moved. Dr. Mpoma, is there a second?
I second.
Great. Well, any opposed? Without objection, May 15th is approved. May 19th through the 21st. Is anybody willing to move that?
Mr. Chair, I do move that the May 19th to 21st minutes be accepted into record.
Great. Thank you very much, Dr. Mpoma. Is there a second?
Mr. Chair, I would second.
Great. Any objections? Without objection. Thank you very much. Looks like we're moving on into the pending cases. Do the commissioners have any thoughts on just taking them in order, or are we fine with taking them in the order that they show up in the agenda?
I'd be fine with that, Mr. Chair.
Okay, great. All right, in that case, I call, are the parties for case 25371 ready to proceed?
Yes, Mr. Chair.
Yes.
Great.
Yes, Mr. Chair.
Well, I will turn the floor over. So this is my first status call. We're getting quite a bit of feedback here, so I don't know if we can get somebody to mute. This is typically my first status conference, so I'll rely on Dr. Mpoma and Commissioner Bloom to advise me here and to help me here. I guess I'll let the parties start and take the floor and advise us on what you guys need in terms of scheduling and what you all envision for the matter to be heard.
Good morning, Mr. Chair, Commissioners, Council, and attendees. Darren Savage of Aberdeen Schill with co-counsel Owen Anderson, who is online, together appearing on behalf of Coterra Energy Operating Company. And I have two other colleagues, Andrew Schill and Bill Zimsky from Aberdeen Schill, who are also online observing these proceedings. And as I understand, we are here for a status conference to set dates, but we also have a motion to stay before the commission.
Okay. Well, since you're the mover of the motion, correct?
Correct.
Yes. I guess we'll hear from you first, and then we'll go to the respondents.
Okay. So, thank you for your time and consideration of Coterra's appeal and request for a motion to stay the division's pooling order in these proceedings. We believe that this case presents important and serious legal issues that need to be addressed and resolved by the commission before the subject lands, the approximately 1,280 acres, more or less, are permanently drilled under an invalid development plan and thereby harmed at great and unnecessary cost to the owners. In effect, these cases involve violations and transgressions of fundamental principles of oil and gas law, conservation regulations, and sound conservation practices regarding both the failure to prevent waste and the failure to protect correlative rights, which Coterra respectfully submits must be addressed and resolved. Thus, this appeal involves a return to Oil and Gas Conservation Law 101. More than 2 years ago, the division was presented with 2 development plans. One is legally valid under the Oil and Gas Act and its regulations, and one is not. Permian Resources presents a plan that drills a duplicative and unnecessary set of 8 wells in the Upper Wolfcamp interval of the Wolfbone Pool that will produce primarily from the Third Bone Spring interval, because geologically, the Third Bone Spring interval contributes most of the production that comes from the Wolfbone Pool. Making matters worse, Permian Resources plans to distribute all production from its additional 8 wells only to Wolfcamp owners. Now, this is clearly an unauthorized taking of hydrocarbons by the owners of the Third Bone Spring, and thus should not be allowed. On this basis alone, Permian Resources plan violates the fundamental principles of oil and gas spacing and pooling laws. But Permian further envisions a total of 48 wells, all to be drilled within 1 year. A voluntary depth severance transaction, that's the boundary of which cuts through the Wolfbone Pool, results in non-uniform ownership across the Wolfbone Pool, creating different ownership between the Third Bone Spring and the Upper Wolfcamp intervals. While these transactions assumed that the boundary between the Third Bone Spring and Upper Wolfcamp intervals created 2 separate pools representing 2 common sources of supply, as would be the correct assumption in most areas of the Permian Basin, this is not true and is the wrong assumption where the subject lands are located due to a very different geology. Here, due to the lack of baffling between the Third Bone Spring and Upper Wolfcamp intervals, the depth severance boundary does not divide 2 separate pools, but rather cuts through a single pool and common source of supply. Coterra recognized this geological fact from the outset when first began conceiving its development plan. Consequently, Coterra recognized that 1 set of wells were needed to produce from this single reservoir. Prior to the contested hearing, Coterra provided the division with an extensive brief that made a good faith effort to fully explain the proper development of this single reservoir. First, to drill fewer wells to prevent economic waste of drilling too many wells, and second, to allocate production from these fewer wells over the entire reservoir pool using an allocation formula that will protect the correlative rights of the owners within this single reservoir. Thus, Coterra is the operator who presented the only legally valid plan for developing the Wolfbone Pool pursuant to the Oil and Gas Act. Unlike Permian's plan, Coterra plan prevents the unauthorized taking without compensation from owners in the Third Bone Spring by wells drilled in the Upper Wolfcamp that would be allocated only to Upper Wolfcamp owners, even though the majority of production would come from the Third Bone Spring. In short, Coterra presented a development plan that drills significantly fewer wells, thereby preventing economic waste, and proposes a production allocation formula that protects rather than violates correlative rights. Permian Resources counters that its greater number of wells will prevent underground waste because they will recover slightly more hydrocarbons. The negligible amount of underground waste that Permian Resources plan claims to prevent is highly speculative and non-additive to the estimated ultimate recovery of the reservoir. To attempt to extract a speculative amount, if there is any amount to extract, Permian Resources proposes to drill additional unnecessary wells that create excessive amounts of economic waste. In addition to Permian Resources' unauthorized taking that violates correlative rights, the magnitude of economic waste inherent in Permian's plan also violates correlative rights because it will deny the owners their just and equitable share of production. And last, but certainly not least, there is the necessary requirement of coordinating to the fullest extent possible the proper application of the Oil and Gas Act and its regulatory framework with New Mexico's initiatives under the Executive Order 2019-003. Coterra takes seriously its responsibilities and obligations to be a good steward of the land and to comply with the spirit of this executive order to reduce the environmental disturbance of its operations. Thus, Coterra's plan takes seriously the state's initiative to reduce emissions. In clear contrast, Permian Resources' plan completely ignores this this important initiative. Coterra respectfully asks the Commission to stay Order R23089-A in order to prevent waste, to prevent the violation of correlative rights, to prevent the unauthorized taking of production from the Wolfbone Pool, to stay a development plan that promotes the drilling of unnecessary wells to prevent irreparable harm to Coterra as a working interest owner, and to prevent irreparable harm to New Mexico's efforts to reduce emissions. And I have my co-counsel online, Professor Owen Anderson, if you would like to, if it would please the commission to hear any comments in this matter from him. Thank you for your consideration.
Thank you. If the commissioners wish to hear from Mr. Savage's colleague, should we briefly, perhaps 5 to 10 minutes? Is that all right with the commissioners?
Mr. Chair, Adam Rankin on behalf of Reed and Stevens and Permian Resources.
Sure.
I'm not sure the procedure here, but I guess normally one council argues a motion at a time. And so I think it's a little bit improper, I guess, to make available a second attorney to make uncertain arguments at this point. So I would just object to the introduction of an additional counsel making uncertain arguments at this point about the motion that has been presented by Mr. Savage.
Okay.
And Mr. Chair, I think that would be in standing with how we typically handle these matters.
What would be?
As stated by Mr. Rankin, yes.
Okay.
Okay,
All right. Well, in that.
the court
go-
report. I just joined. Sorry.
Okay, great. Thank you.
Do you want me to start writing, or is this the meeting I'm supposed to be taking down?
I believe so. Sheila?
Yes, it is. And
Sheila-
I've been recording up until this point, so I can provide you with the video recording up until this point.
Okay, sorry, the other reporter had a issue, and so she couldn't get on. So here I am in the middle of the hearing. So sorry for interrupting, and keep going.
We'll have yeah, sounds like we'll have a recording for you to catch
Okay.
up later. All right. All right. Well, then moving on to Mr. Rankin.
Good morning, Mr. Chair, Chair Chang, Commissioner Bloom, Commissioner Ampoma. Welcome, Chair Chang, to your second day on the commission at the division, and your first day on the commission. We all welcome you. Look forward to getting to know you. Thank you for the opportunity. May it please the commission. I have, given that you guys have very little background in this matter, I do have a presentation I think that might be helpful. And so I will show on my screen here in just a moment. Once I get it up, we can walk through a little bit of the background of this case. And if at the end, if you have questions, I'm happy to address them. So in this situation, commissioners, Permian Resources requests that the commission deny Coterra's motion for stay. Supporting Permian Resources in this motion are working interest owners who have submitted letters of support, including working interest owners who were previously Coterra's largest working interest supporters by percentage. They now support Permian and Reed and Stevens' plan. Coterra fails to establish that they meet the stringent elements necessary to invoke a stay of an administrative order because they don't present actual evidence supporting each of the elements. Coterra simply rehashes the legal arguments and the evidence presented to the division and completely ignores the updated evidence that we provided in response to their motion that dispositively establishes that Coterra cannot meet the elements necessary for a stay. So what are the elements for a stay? The commission has adopted the rules provided by under Tenneco in the Court of Appeals. Those elements are that the applicant for a stay must show that they are likely to prevail in the merits, that there is irreparable harm to the applicant unless a stay is granted, that there's evidence that no substantial harm will result to other interested persons, and that no harm will ensue to the public interest. Applying the standard, the commission has required that applicants for stay make an evidentiary showing on each of those elements. So a showing is a proffer of evidence, actual proof, okay? And not just mere allegations, which would be argument of counsel. Here, Coterra simply rehashes the arguments and the evidence that was presented and rejected by the division below. In addition, the commission has its own regulations that govern this issue, and it provides that the commission may, but is not required to, may grant a stay if it's necessary to prevent waste, protect correlative rights, protect the public health or the environment, or to prevent gross negative consequences to an affected party. So here, Coterra's motion fails to establish evidence on each of those requirements. They do not show that they're likely to prevail on the merits. They can't. They do not show that they're going to suffer irreparable harm. They can't. Nor do they show that substantial harm will result to other interested persons in the case. They can't. Coterra is a lone wolf here. They're the only ones at this point. No other working interest owners support Coterra. All other working interest owners who have been active in the case now support Permian and Reed and Stevens' approach. Nor do they show that there will be harm to the public interest or that a stay is necessary to prevent waste, protect correlative rights, and so on. So just a quick background here. The area and the acreage that we're talking about is Permian's proposed development. I'm going to refer to Permian here. Reed and Stevens is a subsidiary, wholly owned subsidiary of Permian Resources, so I'm going to refer to them going forward as Permian Resources or Permian. The acreage at issue here, the developments are called Joker and Bain by Permian Resources, and they're up in the northern part of Lee County, identified here on this slide by the red. These are each of these are 2-mile tracts. In total, it's 4 sections or approximately 4 square miles. So these 48 wells that Permian Resources is proposing are going to be across 4 square miles, and each of them is going to be 2 miles in length. So since the time this case was heard back in 23, within a year, Permian Resources and its subsidiaries in this area depicted on these maps have drilled and completed more than 500,000 feet of lateral line in 64 wells. They've continued the appraisal, and you can see the acreage here at issue of these 2-mile tracts here on the outlined right here. Permian Resources continued the appraisal and they've drilled all the way around. They've completely developed this acreage.
Mr. Chair, I would object to this presentation because this is going into the weeds of facts that were part of the underlying case, and it does not address the matters of law on which a motion is based. He went through the Tenneco provisions, the 4 provisions of Tenneco, and now we're going way afield, dealing with rehashing, as he claims we're doing. He's rehashing these facts of the underlying case, which we don't feel is appropriate.
Well, yeah, there's to some extent that is happening. Sure.
Sorry, Dave. So obviously one of the main elements, the first element, is whether or not Coterra has been able to establish that they are likely to prevail on the merits. So I do believe it's necessary to some extent to explain what the merits are. And I do not intend to linger on this, but I do need to explain to the commission, because I'm going to explain to you, as was outlined in the motion, how each of these, how the case is likely to go based on the updated information that was presented to the commission. So you understand the context, where the wells are located, what the development plans are, because we haven't established that at this point.
Right. Commissioner Bloom?
Yeah. Mr. Rankin, how long do you anticipate that your intervention here will take you?
Oh, I think like 12 minutes at most to complete the entire presentation. Yeah.
Okay. And all right, thank you. I'm fine with that.
You both need to, Dr. Mpoma, did you want to weigh in before I do?
No, Mr. Chair.
On both sides, you guys have to, there is that factor of the underlying likelihood of the merits. So I understand that you both will need to dive a little, or at least touch on the underlying matter, and you both have a little bit. But in the interest of, but if you, Mr. Rankin, if you could not linger and if you could keep it brief, we'd
Sure.
appreciate it.
I appreciate that. I just want to make clear. So because in the motion, there's a discussion of location and well, so I won't linger, but essentially the acreage that issue is in the box here. There is an offsetting development, which is in this identified by this yellow star. That is a test that establishes the basis for why Coterra is unlikely to prevail. Okay. So next slide here is a little bit of background on the development plans. The dispute in this case is primarily focused on the development of the lower third Bone Spring interval and the upper wolf camp, all within this new wolf bone pool that was created by the division. Coterra's plan, as Mr. Savage articulated, proposes to target only the third Bone Spring interval, partially draining the wolf camp and allocating all that production, including the costs, based on a crude fee height formula that is not supported by any data or evidence and not supported by the statute. Fee height is essentially the porosity of the rock multiplied times the height, which gives you a total pore space or thickness. It's a proxy, approximately, for how likely the rock is going to produce oil. However, and we'll discuss this shortly, it's not an appropriate proxy in this case. In addition, as Mr. Savage alluded to, there's an additional complication here, and that is that there's a depth severance, an ownership depth severance between the third Bone Spring interval and the wolf camp. This is a common issue. It happens all the time, and it's addressed by developing separately these tracks. And I'll explain that as we walk through. Now, under the statute, an ownership depth severance means that mineral ownership across the entire special wolf bone pool here is non-uniform. That makes it impossible under Coterra's plan to allocate production and costs across all owners in the proposed special pool spacing unit on an acreage basis as required by statute. The Oil and Gas Act requires that production under compulsory pooling orders be allocated to the respective tracts within the unit in proportion to the number of surface acres included within each tract as they bear to the number of acres in the entire unit. The Commission and the Division have always interpreted that to mean that when you're force pooling, the ownership has to be uniform within each spacing unit in order to accomplish that goal. Coterra here proposes to allocate production in that manner from their single bench development in the third Bone Spring, but then to allocate it further using a formula of fee height that would result in approximately 27% going to Wolfcamp owners and 72% or 73% going to the Bone Spring owners. That would reduce the statutorily mandated allocation of 100% of production to each spacing unit tract by some made-up fee height formula. That would violate the express mandate of the Oil and Gas Act. It impairs the Wolfcamp owner correlative rights, as I will show you in updated data from actual offsetting production. It conflicts with the division's long-held approach for force pooling space units with ownership depth severances and would upend years of precedent since horizontal well production has been commenced with the division. And there's no actual supporting data that would justify using fee height in this instance. So just a quick overview of Permian's plan. This is just the lower third Bone Spring and the Wolfcamp as part of the Wolf Bone Pool. Permian proposes a wine rack pattern in order to fully develop both the lower third Bone Spring and the upper Wolfcamp all within this new Wolf Bone Pool. Under this approach, it allows, it will create separate pooled space units for the Bone Spring and the Wolfcamp portions of the Wolf Bone Pool. This will allows for uniform ownership. So basically, there's different ownership in the orange or yellow portion than there is in the blue. In some cases, different owners. And by separately pooling those tracts, it allows for the ownership to be maintained uniformly and allows the order to comply with the Oil and Gas Act, which would mandate that allocation of production to owners is strictly on an acreage basis. This also follows the division's long enforced approach for force pooling of depth severed pools, and most importantly, it avoids waste and protects all correlative rights by producing incremental reserves that would not be produced under Coterra's plan and generates more production and more revenue than under Coterra's development plan. How do we know that? Because immediately offsetting, we have a test that establishes that fact. And these are updated data up through May and April of this year. On the left-hand side, you'll see the test that Permian has prepared. On the left-hand side, you'll see the co-development test where there are wells in the third Bone Spring and the Wolfcamp. And then on the right-hand side, you see, which is what Permian is proposing. And then on the right-hand, you'll see a single bench development plan, which is what Coterra is proposing. On the right, you'll see the difference in production between those two approaches. All in blue is the co-development, all in all in red is the single bench development. And you see there's a substantial uplift resulting from co-development. So accordingly, our position is, as demonstrated by offsetting production, co-development is necessary to prevent waste and protect correlative rights. Because what happens here is that owners in the Wolfcamp and in the Bone Spring get more production as a result. What happens when we take that production and we do an allocation to the owners by each company's approach? On the left-hand side with the co-development approach, you'll see that when we allocate on a surface acreage basis, owners in the Third Bone Spring and the Wolfcamp get far more production and value than would owners under Coterra's plan with a single bench approach. This is clearly being demonstrated in immediately offsetting acreage. So as a result, our view is that in order to protect correlative rights, there must be co-development. In order to prevent waste, there must be co-development. Now, what about this allocation plan that Coterra is proposing? In this instance, in this acreage, it's been proven based off immediately offsetting production that using fee height, okay, the porosity times thickness, is not an accurate predictor of the volume of oil that is inherent or maybe produced in the acreage. As you can see on the left, there's a demonstration of that fact. When you look at cumulative oil production and you plot it by fee height, there's no relationship whatsoever. It's almost random, which means that it is not an accurate predictor. You could have high thickness, high porosity, fee height, and relatively low oil production, or you could have low fee height, thickness, and high oil production. So there's no correlation between fee height and oil production, which means that you're going to violate correlative rights if you rely on that formula as a method of allocation. It's not an accurate predictor here, and that's generally because there's higher water saturations in certain portions of the Third Bone Spring than there are in the Wolfcamp, which upsets this allocation methodology. You'll see in the briefing, and I just wanted to address this briefly. If you have any questions about it, I'm happy to go into more detail. But Mr. Savage and Coterra make a point that there is another situation at the division level where the division did allocate production in a forced pooling order. That's the only one I'm aware of ever happening, number one. Number two, it's at the division. It's not precedential for the commission, so it's only persuasive at best. Now, in that case, it involves a single vertical gas well. It's not a horizontal oil well. So the facts are not analogous, and the holding is an opposite to pooling 2-mile oil wells in this instance. It was uneconomic to drill multiple vertical wells to develop different intervals where there's non-uniform ownership. It would be uneconomic to do that. So it was necessary to to target all that gas using one single vertical well. That's not the case here where it's possible to drill horizontal wells that target different ownership intervals. All parties agreed in that case that an order allocating production was necessary for the well to be drilled. If there wasn't an order from the division allocating production, that well never would have been drilled, and there was uncontroverted testimony in that case that was the case. Also, no party opposed the proposed allocation formula that was presented by Devin, the applicant in that case, at the hearing. So there was no protest or no dispute that was an appropriate allocation formula, and that is not the case here. Finally, in this situation, while Coterra did have some working interest support, and even almost the majority of the working interest support at the division level, after seeing the production and offsetting results in the Batman well that Permian has presented, those working interest owners have now shifted their support to Permian. And we presented those letters of support as part of our response. So as a result now, Permian Resources has more than 25%, in excess of 25% more working interest control for both the Bone Spring and the Wolfcamp formations. And under precedent, that is a substantial differential and almost a controlling factor in terms of who should prevail. And no working interest owner currently is actively supporting Coterra's plan in this case. Finally, whether or not there's irreparable harm to Coterra argues that Permian's plan will cause economic waste because they're going to drill all these wells and it's going to cost a lot of money. They also say that under the order, these additional parties, including Coterra, are required to pay, and it will result in waste. First of all, as I showed, it will not cause economic waste because there's going to be more development. Also, these parties, including Coterra, is not required to pay a penny out of pocket under the pooling order or the Oil and Gas Act. Compulsory pooling is specifically designed to prevent recalcitrant owners, such as Coterra here, from unjustly holding up reasonable development and preventing other interest owners here, now the vast majority, from accessing and developing their own minerals. If Coterra believes that Permian plan is imprudent or ill-advised, it can simply elect to go non-consent under the pooling order, but shouldn't be permitted to hold up Permian's proven development plan, especially when Coterra is unable to show through evidence that it will result in waste. The third element here of the stay order, no substantial harm will result to other interested persons. Again, the pooled parties are not required to pay any out-of-pocket costs, but can go non-consent under the pooling order if they deem the plan imprudent or ill-advised. Immediately offsetting developments show a tremendous production and economic benefit that will come to owners both in the Bone Spring and the Wolf Camp. That will not be the case under Coterra's development plan. So there's no way they can show substantial harm to those other additional interest owners. Also, no harm to the public interest. The public interest will benefit from Permian's development due to the substantial uplift in production taxes that are expected to be generated from Permian's plan in comparison to Coterra's. Permian's immediately offsetting Batman shows development, and the Batman shows that $3.4 million production tax benefit from co-development just from 3 wells compared to a third Bone Spring standalone development. Finally, a stay is not necessary under the regulations to prevent waste, protect quality rights, or protect public health or the environment, or gross negative consequences for all the reasons outlined in the slide and that I just reviewed. So based on all this, Mr. Chair and Commissioners, we ask that the Commission deny Coterra's motion. They don't establish through evidence that they meet the stringent elements necessary to invoke a stay. Most importantly, they're not likely to prevail on the merits. That's the first element. And they can't get back, they have to prove all. And if they can't get past the first, they don't get a stay. Coterra simply rehashes the legal arguments and evidence that were presented to the division below and rejected. Coterra provides no substantive response to our updated evidence showing, in fact, with actual offsetting data, that they're going to develop more oil and more revenue for both owners in the third Bone Spring and Wolf Camp. Now, as a result of that demonstrated proof in the offsetting test, the vast majority of working interest owners support Permian over Coterra. No single working interest owner is actively supporting Coterra. And no working, so that was the last point. So with that, Mr. Chair and Commissioners, we ask that the Commission deny Coterra's motion and that we now set this for a evidentiary hearing on the merits.
Thank you. I imagine Coterra probably wants to respond, but first let me turn to my commissioners and ask whether they have any questions at this time or whether they want to wait until after.
Mr. Chair, it might be helpful to hear from the OCD or see if they have anything that they might want to contribute.
OCD has not entered as a party in this case. So
Then no, sorry about that.
Yeah, sorry. Mr. or Dr. Mpoma, any questions at this point in time before we ask Coterra to respond?
Yeah, Mr. Chair, probably if we can listen to the response so we can have all the information and then probably we can proceed with some questions after that, if that is okay. Thank you.
Of course, it's the Commission's pleasure. Go ahead, Coterra.
Thank you, Mr. Chang, Chair. Mr. Rankin, could you go to your slide where you have the Joker Bain plan of the stacked wells? Okay. So, Mr. Commissioners and Mr. Chair, this is what Permian proposed during the contested hearing, and as you can see, there's 4 Basil Third Bone Spring wells in the yellow, and proposed 4 Wolfcamp wells, and they're claiming that all these Wolfcamp wells must be drilled in order to prevent waste, and we're claiming that if you drill all these Wolfcamp wells, you will create waste and violate the owner's correlative rights. Now, Mr. Rankin, would you please go to the Batman slide? Okay, here is the Batman slide, the Batman development plan as it was drilled. Now, as you can see, the majority of the wells are located in the Basil Third Bone Spring, and that's because, as we point out in the geology in this area, that is where you get the primary production. Notice that they only have 1 Wolfcamp well. Now, if you look at the original applications and you look at the original pooling orders, they proposed the exact same stack plan in the Batman that they proposed in the Joker and Bane. They proposed 4 in the wells in the basal third bone spring, and they proposed as necessary wells, arguing they're necessary wells, 4 in the upper Wolfcamp. But when you actually look at what the plan that they actually developed, it basically mirrors Coterra's plan, and that is the emphasis on the basal third bone spring. And what they did is they drilled all the basal third bone spring, and then they drilled this one token upper Wolfcamp well, and then they had 3 other orders, R2278, R2279, and R2280, in which they let expire. They basically relinquished their rights to drill the additional 3. So this really contradicts the development plan that they actually proposed and argued for at the original hearing, and it basically supports the need to develop the basal third bone spring. In addition, I'd like to respond to the FEH or Coterra's allocation program allocation formula based on the FEH criteria. So here's the baseline, the base argument, the baseline on this on the differences between the plans, and that is it is incontrovertible that Permian Resources plan is going to drill the upper Wolfcamp, and then they're going to produce the Wolfbone pool. Now, if you look at the findings of the division, you will see that any well drilled in the Wolfbone pool, whether it's in the Wolfcamp or in the Bone Spring, it's going to produce the entire Wolfbone. It's going to produce from both intervals. So what they're going to be doing, and they're distributing all the production from their Wolfcamp wells only to the Wolfcamp owners. That means they're taking 72% of the hydrocarbons from the third Bone Spring, different owners up there, and they're giving it to the Wolfcamp owners only. Now that is a classic taking. It's a taking without compensation. And so it's clear that Permian Resources plan is illegal. It is illegal under oil and gas law. So the conclusion of that is that there needs to be an allocation formula. There needs to be some kind of allocation that protects the rights of and distributes to protect the rights of both the third Bone Spring and the Wolfcamp production, regardless of which wells are producing those. Now, we have been wrestling with this over 2 years to come up with the best allocation, and we stated this initially in our comprehensive brief that we submitted prior to the contested hearing, in which we discussed various ways to allocate interest so that correlative rights are protected. Now, so we finally came up with this idea of doing it based on the FEH. And now this is really getting into the weeds, but there is a lot of factual matters that Coterra can show you that Permian Resources did not show you in their presentation of why the FEH would be a very reasonable, logical, and accurate basis for an allocation formula. And I think that would be reserved for a hearing on the merits. But basically, the case, I mean, Mr. Rankin said that there was only one case, and that was the Devon case, in which they deviated from the surface acreage requirement under the statutes, but that's actually not true. There's actually several cases where the New Mexico Supreme Court actually allowed the OCC to modify the surface acreage interpretation in order to arrive at a plan that would not violate the Oil and Gas Rights, Oil and Gas Act. So one of those cases is Rudders versus OCC. In that case, there was a tract that was non-producing, And I mentioned this, I talk about this in my motion, but there's a tract in the unit that was non-producing, or it looked like it was non-producing. And so if you went based just on the surface acreage requirement, those owners in that tract would not receive any share of production. So what the OCC did is that they modified the interpretation of that provision in the pooling statute to allow them to receive their share of production, and it was not based on surface acreage. It was a deviation from that, and the Supreme Court actually said that they would uphold that formula, the allocation formula, because it was reasonable and logical, and it prevented the violation of correlative rights. So it's a clear dividing line. Their plan is legally invalid. Our plan is legally valid. It just needs the proper allocation formula, and we believe the PH is the proper allocation formula. And then in terms of economic waste, under Coterra's plan, the owners would receive, and we have exhibits that we presented at the contested hearing, anywhere from 2.4 to 3 times as much revenue as they would receive under Permian Resources Plan because of the severe financial burden on the working interests. Now, he claims that there's all these owners that have gravitated towards Permian Resources Plan, but that would be reasonable if they're shown what they believe is a valid order from the division, and they say that these wells can be drilled immediately based on this order. Of course, there are going to be a number of owners that are going to be enticed to gravitate, but I don't believe that they fully comprehend the legalities involved in that order and the implications and the consequences of that order. So, for example, that order actually completely disregarded any form of economic waste by what we believe was a misapplication of a specific provision in the commission order, a previous commission order. And therefore, none of the evidence that dealt with economic waste in the underlying hearing, the contested hearing, was even considered or reviewed because they categorically, as a matter of law, excluded it. Here at the commission, we believe that the commissioners should look at the evidence de novo, and that is also the evidence for the motion to stay. And a de novo review, that means looking at the evidence anew, would show that we satisfy the TANECO requirements. If the underlying case were decided on proper legal grounds, we would be very much likely to prevail. Because economic waste was not even considered, that is a harm, an irreparable harm that would occur if Permian Resources Plan is allowed to go forward. Other interested parties would not be harmed because if Coterra's plan were found to be the proper plan for protecting correlative rights and preventing waste, the owners would receive 2.5 to 3 times as much revenue from production of its plan. The amount of the incremental amount of production that they claim is very speculative, and you can see that in the testimony. It's very negligible, and it's not additive to the EUR. And then what we consider the most important thing, and the Permian Resources doesn't even address this, is the Oil and Gas Act prohibits the drilling of unnecessary wells. And if you drill unnecessary wells and you promote a policy that encourages the drilling of unnecessary wells, then you basically promote excessive emissions that the state is on the record as trying to reduce. So, and that is something that Permian Resources did not even address in its response, nor did it address in its presentation, even though it is a central thesis of Coterra's motion to stay. And there's also another case that shows how the division and commission has reinterpreted that pooling statute. And if it would please the commissioners, I would like my co-counsel Owen Anderson who has a lot of experience in dealing with conservation regulation to address that particular case.
Well, that drew an objection last time, but how commissioners, it's your decision. Would you like to hear from Mr. Savage's co-counsel?
Is Mr. Rankin objecting to that, or he has no objection to that?
Well, generally, thank you, Commissioner Ampoma and Chair Chang. Generally, when presenting arguments, one counsel is assigned to that, respond to questions and make the argument. So I think it's important for the decorum of the forum to maintain that. And Mr. Anderson is not being, he's not an expert witness. And so he's co-counsel, and I think it'd be inappropriate to have him sort of be testifying to the commission on something rather than allowing Mr. Savage to make the arguments.
Chair, go ahead.
Oh, I mean, I hear Mr. Ranking, but I think ultimately it's up to the pleasure of the commissioners. So it's up to you, Dr. Ampoma and Commissioner Bloom. We can certainly proceed without at the moment. So it's I guess I'll give Mr. Savage a quick minute for his thoughts.
So Professor Anderson has written over 100 articles, many including spacing, allocation, pooling, correlative rights, waste. He's a noted expert, a legal expert. He is part of our legal team. I discussed with him the areas that he would discuss for the benefit of the commission, and the areas that I would discuss for the benefit of the commission. So if the commissioners want the full benefit of the analysis, the legal analysis that is directly impacting and affecting this decision, I think it would be useful and beneficial. And we respectfully request that the commission avail itself the benefit of his presence.
Thank you. I want to try to keep some boundaries on this hearing so it doesn't devolve into a full-on trial on the merits right here with everybody sort of without us being fully organized for that. But I will take the opinions of my commissioners. Commissioner Bloom?
Yeah. Mr. Chair, I would just ask Mr. Chandler if he has any insights to share with us here.
Mr. Chair, I don't have any unique insights.
May I make a brief just comment on this point, Mr. Chair?
Sure.
Generally speaking, when we are arguing motions, we're limited to the papers. And so if Mr. Anderson is going to be making additional arguments outside what has been presented in the papers, I have a problem with that, number one. Number two, I have a problem that he's being presented as an expert here as if he were a witness. I think that's also inappropriate. If there's arguments that were made in the papers that Mr. Savage wants to articulate, he's welcome to do that. If there's specific issues that I raised in my response, he can address those on a legal basis. But I don't think it's appropriate to introduce an expert in legal matters at this point in this argument.
Commissioner Bloom. Yeah. Oh, sorry. Who was speaking?
Oh, I'm sorry. I was just going to respond real quickly to that. So Mr. Anderson is not a witness or an expert witness. He is an integral member of our legal team. He would address the legal issues that were addressed and raised in the papers, both in the motion to stay and in the response and in the reply. So if the commissioners want to have the benefit of the full scope of our legal team, then Mr. Anderson's available.
Got it. Commissioner Bloom, you still have your hand up. Wasn't sure if that was intentional.
Mr. Chair, yes, thank you. Traditionally, we have heard from one attorney from each side, and I believe that's appropriate, and we should stick with that.
Okay. So unless, and that doesn't, Dr. Ampoma, you don't have a concern with that? You're all right with that?
Yeah,
You're
so Commissioner Bloom, So Mr. Rankin is saying that Professor Anderson can respond to the motions that or the thoughts that he presented in his document. But I think he can also object to any additional item that is outside the scope. So if Mr. Rankin is not objecting to that, I will say that probably let's hear from Professor Anderson, but Mr. Rankin do reserve the right to object to any thoughts that is outside the documents that have been presented to the commission.
Oh boy. Yeah, I mean, I think that's the issue here, right? Like, neither side should have witnesses, or expert or otherwise, at this hearing. Though the co-counsel is being offered as co-counsel and not as expert witness, would be limited to what is in the scope of the briefing. So really, it comes down to, do the commissioners have specific issues that that second counsel would be able to address that Mr. Savage would not be able to address if it's already in the briefings? I'm
Yes,
leaning
Mr. Chair.
toward.
I'm
Go
sorry,
ahead.
Mr. Chair, if I may, I'm sorry to interrupt, but if I may, if this would help, if I cede any additional time that I have available to my co-counsel, Mr. Anderson, would that help resolve this matter?
Mr. Chair,
Go ahead, Commissioner Bloom, please.
yes, Mr. Chair, I believe that, typically for these sorts of motions in front of the OCC, each side comes prepared. They select a lead attorney. That person makes their arguments, and I can't think of another time we've done it differently. So
Fair enough. So my apologies, Dr. Mpoma, and my apologies if anybody traveled without the opportunity to be here today. But I will defer to, or I will agree with Commissioner Bloom's advice, and I'd rather that we continue today. Mr. Savage, do you have anything else to add from your side, or can we open the floor for commissioner questions?
I guess open the floor for questions. Thank you.
Great, appreciate it. Dr. Mpoma or Commissioner Bloom, I turn the floor over to you two.
Mr. Chair, I would just have, I think, a couple of quick questions.
Go for it.
Yeah. Mr. Rankin, Mr. Savage stated that there's an illegal taking here. I wanted you to address that specifically. And Mr. Savage, you can have the opportunity to rebut.
Yeah, I appreciate that. I mean, I think it's important to understand what, first of all, I'm not going to go into detail about what illegal taking is. A taking is taking a property without compensation. That's not the case, okay? As demonstrated by this, in fact, presentation of the data offsetting, there is a clear demonstration that owners in the Third Bone Spring will get more production, and Wolf Camp owners will get more production under Permian's plan because of the co-development. When you co-develop properties and you complete them and stimulate them at the same time, you're going to get a more complex fracturing between the two benches, and you will get more production. And that will be demonstrated at the hearing on the merits. But that's what's happening when you co-develop, and that's why when you co-develop and stimulate at the same time, you get enhanced production. And that was what was the purpose of this test, to show that offsetting. And that's why they didn't drill the Wolf Camp immediately adjacent to this Wolf Camp co-development test. So in fact, when you look at it and you compare between the two, is there a taking from the Bone Spring owners as a result of the drilling of the Wolf Camp? Well, the answer is no, because these owners are actually getting more production and more value. The Wolf Camp owners, are they getting a taking occurring to them? No, because they're getting more production and more value. What is important to understand when you look at the definition in the statute and the regulation of what correlative rights are, okay, it's difficult to ascertain specifically with complete accuracy how much oil or gas is due to any one owner. And it's what the way the correlative rights statute and regulation is set up is it's based on what is practicably determined. Okay, what can be practicably determined? Coterra proposes that it can be practicably determined using a fee height formula, but as shown in the evidence, that is not the case. So what is the alternative? The alternative is to co-develop, and not only is that the best alternative, but it also results in the best production. And so while we're not having an allocation, which is a separate allocation from what the statute requires, okay, which is per se protective of correlative rights because it's what the statute requires. We are also showing that by doing what the statute requires, you're also protecting correlative rights, and there is no taking. Now, I want to make sure one other thing is abundantly clear for the commission, so the commission is not misled. Mr. Savage referred to this case, the Rudder and Woolbanks case, and he said that the commission in that case diverged from the statutory formula. That is not the case. The commission, as you'll see and I've highlighted in yellow here, you'll see this is the Rudder and Woolbanks case that he was referring to. In that opinion, they specifically state that what the commission did was establish a participation formula, giving each owner in the unit a share in production in the same ratio as his acreage bears to the acreage of the whole units. That's exactly what the statute says. They did not diverge from what the statute required. And they did what the statute required. It's exactly what the statute says, which is exactly what we say needs to be done here. Okay. So there is no taking. There is no taking because the owners are going to both get more than they would otherwise get.
Mr. Savage?
Yes, thank you, Commissioner Bloom. If Mr. Rankin would pull that Rudder's statement holding up. So in that Rudder's case, so the literal terms of the pooling statute, it says that in order to determine the individual ownership, you first have to do it on you have to determine what the surface acres, each individual tract based on the surface tracts would be allocated production. And there could be a whole number of owners within a particular surface tract. If you project it down onto the unit that's going to be producing the minerals, so you could have, for example, 5 owners within a particular tract based on the surface acreage, based on the surface, the shape and size of the surface tract. Okay, so those 5 owners within that tract would be allocated ownership based on how much is allocated specifically to the specific surface tract. Okay, so if the geologist says that that's a non-productive tract in that particular area in the unit, that tract would not produce any hydrocarbons, then those 5 owners in that tract get 0. They get 0 production. Okay, that's what occurred in this Rudder's case. And so instead of applying the literal language of the pooling statute, which says you have to allocate to the surface tract, what they did is they allocated, instead of on the basis of a surface tract, they allocated across the unit on an individual basis. So everybody, regardless of where you're located, everybody who has net acres in that unit is going to get the amount of interest as the net acres is in proportion to the total acres of the unit. That's completely different, very different. That's a total deviation from the pooling statute. And they did that to protect the correlative rights of these owners in this one tract where they thought that tract would not produce. So, in terms of a taking, so the OCD actually found that these Wolfcamp wells that Permian Resources plans to drill just in the upper Wolfcamp and produce, those wells are going to take actual production from the Third Bone Spring, and actually it's going to be the majority of production going to those Wolfcamp wells, or it's going to come from the third Bone Spring because that is the most productive interval, and that was found to be the most productive interval by the division and by the Coterra's geologist. Okay, now there are owners in the Upper Wolf Camp who own exclusively in the Wolf Camp, and they do not own in the third Bone Spring at all. Therefore, they have no right to receive any production from the third Bone Spring, but Permian Resources is going to distribute that allocation, that production to those owners that own only in the Upper Wolf Camp. They're going to give probably two-thirds of that production comes from the Upper Wolf Camp, from the third Bone Spring. They're going to give it to those owners that have no right. That is a classic textbook taking. Now, it doesn't matter that we don't know what the overall allocation would be in the Wolf, but we don't know that the third Bone owners are going to receive more, or that or to compensate that loss, to compensate that taking. Basically, the Wolfbone Reservoir is a single reservoir. It has a limited and restricted EUR. Now, if you drill 2 duplicative sets of wells, you may accelerate production, but you're not going to get extra production. If you drill the basal third Bone Spring, you're going to get the same EUR practically. There might be some negligible difference, but that is very speculative. So you can get the same EUR, and you're going to get it in a manner that prevents the actual taking. Now, if you in a footnote in our motion to stay, we cite Manning versus Energy Minerals, and so it said actually there was a holding. It's New Mexico Supreme Court that shows that an agency that uses its police powers to authorize a taking without compensation is unconstitutional, and it's subject to the takings clause. So we think this is a very serious legal issue, and we think this is a legal issue that would prohibit, as a matter of law, Permian Resources development plan as proposed.
Okay. Thank you, Mr. Savage. So my next question to both of you then, and I think kind of extends from this. Mr. Savage, why did we see this exodus of working interest owners from Coterra to Permian Resources? Looks like, people voted with their feet here. Most of the companies that come in front of us are pretty savvy. They do an economic analysis. I guess probably the last question here would be, are you suggesting that these companies are allowing their minerals to be taken then?
Commissioner Blinn, that's a good question. So if you look at that, the first group is the Hudson Group, and I believe that they're a family that has a lot of ownership interests. They have been supporting Coterra since its conception of its plan, and they did gravitate. Now, I would say that their motivation would probably be they just want the wells drilled, and I don't think they understand the full implications of this order. I think the order is clearly misapplied the commission policy. Commission orders and OCD orders are like the case law of the commission and the division. They are equivalent, setting precedent, setting conclusions of law within the parameters of application of the Oil and Gas Act, the same as district court cases set precedent. The order clearly misstates commission policy, and it does that, and it uses that misstatement to exclude a very important issue of waste. I don't think that somebody like the Hudson Group understands the full legal implications. I think they understand the liability that other owners could possibly act upon and develop a cause based on the taking, that they as working interest owners would possibly be entangled in and be involved in. I think they just see that the division They assume it has expertise and that they, want to get those wells drilled. Now, if I'm correct, I don't believe the Hudson Group actually issued a letter. I believe Javelina, is that correct, Mr. Rankin? The Hudson Group did not actually issue a letter of support. Javelina, who has a much smaller interest, issued a letter of support. So that's one. And then let's see, what was the other letter of support? There was one other letter of support. So that does not address all the working interest owners. The Hudson Group is the larger group. They claim, Permian Resources is claiming that it creates about a 25% working interest difference now. However, they are basing their calculation of working interest based, again, on the presumption that these are two separate pools. So they calculate working interest in terms of the working interest for the Wolfcamp and then working interest for the Third Bone Spring. But actually what we're looking at is the working interest in the Wolfbone pool. And if you actually do the calculations of the Wolfbone pool based on the weight of each interval that would be contributing, you actually get a very different calculation of working interest that very much closes that gap. At the time of the hearing, looking at the after the Wolfbone pool was created, we ran numbers that looked at the working interest, and in that working interest, Cimarex or Coterra was way ahead of the game in terms of working interest. We believe that if you run the numbers based on the allocation of the Wolfbone pool itself, you would get probably interest that's probably closer to being on par. And you also should point out that, in the 7 factors that the commission and the division considers, those are prioritized, and geology is the number 1 factor, and I believe working interest is down at the bottom, somewhere around number 6. So working interest is not dispositive, and if there's a legal issue that prohibits a development plan, it doesn't matter how many working interest owners would support it. It is just prohibited under the Oil and Gas Act. And the geology is number 1, and we wouldn't be here today unless Coterra's geology was correct and Permian Resources geology was wrong. And that's what it turned out to be. We proposed from the very beginning, and we even asked for a pre-hearing conference to confirm that the Third Bone Spring interval and the Upper Wolfcamp interval represented a single reservoir, and that the division should make a decision based on that. And Permian Resources fought that tooth and nail all the way up to the hearing and through the hearing. And then if you notice that the final order that was issued, they confirmed Coterra's geological analysis, and they rejected Permian Resources' premise that there are 2 pools. So I do not think the working interest is dispositive. I don't think it's reflective of the actual intent of all the working interest owners or the harm that they would receive from the implementation of this plan.
All right. Thank you, Mr. Savage. Mr. Rankin?
The question is why do I think that working interest owners shifted over to Permian Resources plan?
Correct. Yes. Or just, if you had any sort of response to Mr. Savage there.
Yeah, I mean, I think, I can't speak for them or what they think, only what they put on the paper. The Hudson Group and Javelina, they are a very savvy group. They've been around for a long time, and they have been involved with many, many deals. And they've, I think, very well understand what's at play here and understand the benefit of co-development. And so I think, without speaking for them, all I can say is I think the numbers and the offsetting tests speak for themselves. And I think ultimately that is what is driving the interest of the parties is to maximize production for the benefit of all, including the state. And that is what the offsetting test shows. And that's the development plan that Permian has implemented in all of its offsetting tracks and intends to do so here, and is eager to be able to get that development project on the ground and running.
All right. Thank you. No further questions.
Dr. Mpoma?
Thank you, Mr. Chair. I do have some few questions for both parties. So the first one is to Mr. Savage. So just following up from the previous, just the end, previous discussion. So there is a shift of the working interest owners to the side of Permian. So then how are you going to operate if you do not have the majority interest, let's say to more or less develop those pools?
Okay, thank you, Commissioner. So those few letters, and they're not a substantial amount, they are just a support letter. They are not, although I believe, okay, so Hudson Group did sign the JLA. But if you look at just the amount of working interest, we are still on par. We have substantial amount of working interest and are still on par for all practical purposes with Permian Resources. Like I said, working interest is a lower factor in the factors that the commission and division consider. Now, if the commission decides that Coterra's plan, as a matter of law, protects not just popular support, but as a matter of law protects correlative rights and prevents waste, and Permian Resources does not, then an order issued to Coterra would allow Coterra to control and govern all of the working interest. So they would be able to operate under an order, a pooling order issued to Coterra, because at that point, all the interest would be pooled in the unit, and Coterra would be granted operatorship with the right to operate that interest. So that, that's really how that operates. So that is why this question of a matter of law and taking is really the critical question. And it's a complicated legal question, and I really do think that, I know the commission said they didn't want to hear from Mr. Anderson, although Commissioner Ompama said he would consider it. But I really think that it would be benefit to the commission to have the analysis provided by Mr. Anderson.
Thank you, sir, for your response. Now, to Mr. Rankin, so in your presentation, you talked about there will be no out-of-pocket cost to the other owners. So can you explain that to the commission?
Thank you, Dr. Mpoma. Under the pooling statute, once a pooling order is issued, the operator who's been awarded the right to operate a spacing unit under a pooling order is then required to submit AFEs and an opportunity to elect under the pooling order. So if the party hasn't already voluntarily joined into a proposed JOA and is voluntarily committed to the development of that acreage, once a pooling order is issued, the operator is required to send out an updated opportunity to elect under the pooling order substituting for a JOA. At that point, then a force pooled interest owner has the opportunity to elect to participate and pay their share of the costs under the pooling order, or they can elect to go non-consent and not pay their share under the pooling order. If they elect to go non-consent because they don't think it's a good plan, they think it's ill-advised or imprudent, then they are deemed a non-consenting pooled working interest owner, and they don't have to pay any money out of pocket. But as a consequence, however, they are normally assigned a 200%, maximum 200% interest charge, risk charge, plus actual charges. So that amount comes out of the production from the well. So they don't have to pay anything out of pocket, but once the well produces, then their share of costs comes out of production until the well pays out, and then they get their share of the revenue.
Thank you. Mr. Rankin, so did Permian opposed to the de novo request from Cotera?
Is your question, Dr. Ampoma, whether Permian sought the de novo appeal?
No. Are you opposing the de novo?
Oh,
Yeah.
yes, 100%. Yes, we
Okay.
oppose it, and we want to, well, I mean, we have to, I mean, by statute, Cotera has a right to a de novo hearing. But we continue to oppose Cotera's plan of development and think that Permian Resources plan is the proper and most prudent plan.
So I'm asking this to both parties. Is there any items that has changed, from the original case aside the working interest that we've just discussed?
If you don't mind, I'll answer that initially. But Mr. Ompama, if I may just make a comment real quick on the question that you asked Mr. Rankin about the costs under the pooling order. So Permian Resources has been mandated to drill 48 wells in a year. And there's no way. They actually acknowledged under the hearing that there's no way they can do this. That is a total cost of $529 million or thereabout. I think that's the correct, somewhere in that range, over $500 million. And that's $256 million more than Cotera's plan. That's $250 million more than Cotera's plan. Now, Mr. Rankin is correct. He mentioned that there's a party can go non-consent, but there's a 200% risk penalty that you incur when you do that. When you start applying the risk penalty to those amounts, that is a huge cost that you incur that would, we believe that additional $256 million is economic waste and violates correlative rights. But we want to make sure that there's a perspective on what it means to go, the consequences of going non-consent. So tell me, I'm sorry, tell me your original question, the question I need.
Yeah, Mr. Savage, so I'll follow up with your response on what you just said. Now, is it also the case for Cotera that, let's say, if the commission grants you your request to develop, you're also not going to apply the 200% to the other parties who do not consent to participate?
Cotera wants to participate in the development plan, but they want to participate in the development plan that's economically reasonable, not economically irrational. As you can see on those Batman wells, they did not drill all those Wolfcamp wells that they proposed. They proposed the same kind of stack that in the Batman that they did in the Joker and the Bane, but they did not follow through because they know it's an economic waste. And now the OCD has mandated that they drill all those Wolfcamp wells. But in terms of the exact plan that's going to be proposed under de novo, I believe that was your question. Is there going to be any modifications? So do I understand that correctly?
Yeah. So the question was: is there any items that has changed? From the original case that the OCD issued the order?
Is there any change that has occurred since the last case that the commission should take into consideration?
You can put it that way. Yes.
So let me just address a couple of aspects of that question. So one is when Cotera developed this plan, they saw very well that the basal third Bone Spring is the emphasis. It's the primary producer. The third Bone Spring interval is the primary producer. The Upper Wolfcamp is ancillary. The Batman plan that Permian Resources did, basically confirms that, and it basically mirrors Cotera's plan of emphasizing the basal third Bone Spring. They drilled one token well in the Upper Wolfcamp, and they're claiming that is sufficient to prevent waste. But so on a de novo review, we still have the same basic plan, and that is emphasis of producing from a location at the basal third Bone Spring. But as Permian Resources pointed out in its response to our motion to stay, these plans were originally configured, also influenced by there being two pools. So it's possible that it might be useful to consider an additional single wolf camp well properly positioned that might account for some incremental interest. And I think that our Coterra discussed that during the hearing, and I believe that Coterra Permian Resources referenced that discussion. So I think giving the fact that we're looking at this decision in relation to a newly created wolfbone pool that was created after the decision, after the contested hearing, that was based on there being the presumption there being two pools. I think that really kind of changes the number of issues that the OCC might want to consider and allow, maybe some variation to account for this new addition of the wolfbone pool that the OCD confirmed that Coterra's geology was correct. So the other thing that I really would like to emphasize that what has changed, and that is the nature of the division order. And we feel, if you look at that, we talk about it in our motion to stay very clearly. We isolate the provision that the division used to exclude all the evidence that addressed and the questions that addressed economic waste. And they actually changed that. Statement. They altered the meaning of the statement and the purpose of the statement, and they used it to exclude a comparison of the total development costs between. And that statement was never intended. That statement was intended only to look at individual AFEs on individual vertical wells, and to use that to exclude a whole area of waste that the statutory definition requires and case law requires you to include and to address. We feel that's a gross misapplication, and we think that if the OCC decides in favor of whatever party decides in favor of Permian Resources, decides in favor of Coterra, that order needs to be rewritten in order to address the negative policy implications and consequences of that order. So, that I would say that's really an important consideration, that order needs to be revised to account for the negative policy implications of promoting the drilling of unnecessary wells and promoting excessive emissions, which we think it violates the executive order and the state's initiatives.
Mr. Savage, so you made a comment that in your view, the interest owners did not, fully ascertain the order that was issued by the OCD. Do you have any evidence to this, or is just a speculative thought?
I have hearsay evidence in discussions with my client. If you want to hear that, because the OCC and the OCD can consider hearsay as probative evidence. But that would be up to you.
So you also made a comment that, or what I got from your comment or your statement was that the OCD did not do due diligence on the geology. Is that correct?
Yes, we think that is, it's clear on record when the parties went to the OCD to get the pool classifications, they designated the third Bone Spring interval as a separate pool and common source of supply. Then the Upper Wolfcamp interval also they designated as a separate common source of supply. Now our geological analysis from the very beginning, that's why we stood by our geological analysis, and that's the number one factor. That is the number one factor to consider in granting operatorship. Is the nature of the geology. We were correct on that. And we actually asked for a pre-hearing conference. We wanted the division to look at, to reevaluate these two pools and determine whether or not they're two pools and two reservoirs or a single reservoir and one pool. And the OCD refused to, they agreed to the objections of Permian Resources. They said that the OCD, it wasn't their responsibility to assign pools, even though they did. I mean, it is their responsibility. It was our responsibility, to, I guess, to argue that during the hearing. So they agreed with Permian Resources. So we did not have a pre-hearing conference that would have determined it was a single reservoir. And we went through the whole contested hearing on the presumption, on the assumption that it was two pools. And under cross-examination, Permian Resources, their witnesses admitted that there was no natural barrier and no baffling between those intervals, and it constituted, shared production. So the OCD, instead of awarding one of the parties operatorship, which we believe they should have awarded us, and we don't know what the original hearing examiner actually, what her report was. We don't know what she recommended to the division about who should be operator, because that has not been disclosed. But she's a very sophisticated hearing examiner with lots of experience in oil and gas. So we would not imagine that she would have granted or recommended that Permian Resources be granted operatorship. But we don't know, because we had a change of hearing officers and transitions, and other folks took over the supervision. So So 9 months after the contested hearing, the OCD issues an order and they confirm Coterra's geological analysis. And that's when they asked the parties to propose a application for a WFBone, pool, which we did. And Coterra joined in a joint WFBone application on the reliance that it would be able to later submit its allocation formula in revised pooling applications. And that was we saw that as being agreed to at those hearings for the WFBone pool. And then if that was later denied, we feel that's arbitrary. That was arbitrary and capriciously denied. And so, yes, so we're 2 years out now. If we had had that pre-hearing conference, this thing would have been settled at the contested hearing at this point, we believe. But the OCD did misclassify those, and then they fortunately corrected and created the correct pool. But they allowed Permian Resources to maintain its antiquated development plan that was based on two pools and unnecessary wells for that Upper Wolfcamp.
Thank you for that. So I do have one question for Commission Counsel. So Commission Counsel, we've listened to Mr. Salvage and Mr. Rankin with regards to the illegalities that Mr. Salvage pointed out. I wrote down two items. One is order misapplied, meaning the OCD order misapplied OCC precedent, order misstate OCC policy. And even he also talked about, the current order do have negative policy implications. I mean, can you comment on this?
Mr. Chair, I cannot comment right now. These are just allegations, and the allegations are that the division hearing officer acted inconsistently with prior precedent. But I have not conducted a review to give an analysis at this point.
Council, so here we do have two issues. One is the de novo request, and then one is the motion to stay. Is it correct that these are all interdependent on each other? Because if we pick up the de novo case, then automatically does that stays the motion, or no? I just need some guidance on that.
Mr. Chair, I do not think taking up the de novo grants an automatic stay, and I base that on the fact that they have filed the motion. I do not know the practical effect. The lawyers have been arguing the law, or the status of the current application is, nor have we heard the specifics of when the lawyers intend to have the hearing, how long it will last, when the decision might be reached. But I'm talking too much. Your question was, does a filing of a de novo create an automatic stay? The answer is no.
Okay. Mr. Chair, I will not have any further questions at this time. Thank you.
Okay, thank you. Unless do the commissioners feel like we're ready to deliberate on at least, let's take them separately. We'll deal with the status and the scheduling separately. Let's just deal with the motion on stay at the moment, a motion for stay. Are you ready for deliberations? This is my first one and I'm not ready to have a deliberation I'd like to have a closed or a in camera for deliberations. So if no objections to deliberating at this time, commissioners?
Yeah, Mr. Chair, I do support closed session to deliberate on this. So yeah, I do support your session on this one. Thank you.
Okay. You were saying something, Commissioner Bloom?
I'm sorry. Yes. Yes, Mr. Chair, I would be comfortable with a closed deliberation, and perhaps just one final question for Mr. Rank. I'm sorry, for Mr. Savage regarding how this plays out, if you'd permit me.
Of course, please.
Yeah. Mr. Savage, so you're asking for if you could just speak to the necessity of the stay before the de novo.
We believe that the stay is necessary. We believe that we've fulfilled all the Tenneco tenets for satisfying the stay. We also feel like there's a due process issue that should be considered, and that is the 7213, which grants a de novo hearing. We don't see where if you would have a fair de novo hearing if while you're having a hearing on the merits that Permian Resources out there drilling their wells and implementing their plan and basically permanently damaging, from our perspective, damaging the subject lands. It would seem like it'd be more fair to allow a hearing on the merits, especially, and I could see in a situation where you don't meet any of the Tenneco tenets, you don't have any arguments, there's no policy issue, and there's no serious issue on a legal matter, a breach of the Oil and Gas Act and the clear violation of clear. If you don't have any of those, I could see where you would not grant a stay and allow parties to go forward on the hearing the merits because there is less risk. But here we have a whole variety of issues, matters of law, which we feel very strongly, and those are appealable issues. To district court, it would be the next level. And the policy issues that this is an order that actually encourages the drilling of unnecessary wells, and they encourages it as a pretext for parties, for larger companies who can actually afford to drill a lot more wells. They can present, let's say, we're going to drill 6 wells in this unit because we're going to prevent incremental underground waste, and it doesn't matter that you have all this economic waste that the owners have to pay for because that's not even a factor to be considered when it is under the Oil and Gas Act. And they can do that as a pretext, and then they can just like go down their way and say, we'll drill whatever we want. We've been granted operatorship. We said we're going to drill 4 wells in the Upper Wolfcamp, but we have this Batman development plan. We're just going to drill 1 token Upper Wolfcamp well. I think those are serious policy issues, and I think a stay is warranted and merited and is very prudent under these circumstances.
Thank you, Mr. Savage. Mr. Rankin, one final question to you, as Mr. Savage reminded me of kind of going back to the beginning there with Tenneco. Should there be, I'm not going to say how low of a bar, but how do we set a bar? How do you think about Tenneco irreparable harm and harm to others if, just to issue a stay. I mean, we are talking, we've seen Mr. Savage's, Katerra's position that their development would cost $250 million less. So that does get into some issues of waste and considerable harm to others given the larger cost. I'd like to know your thoughts on that, please.
Thank you, Commissioner Bloom. That's the whole point of the Tenneco factors, is that an applicant seeking to stay in order has the opportunity to come forward to the commission and any administrative body to present actual evidence that would justify issuance of a stay, precluding an operator here under a validly issued division order from going forward to do what they are not only authorized to do, but as Mr. Savage pointed out, required to do, which is to drill these wells. The fact that Mr. Savage is here arguing about economic waste, but hasn't actually shown it with any data, I think is a strong indication that they're unable to meet the very first element of Tenneco. In contrast, we have clear offsetting production that has been updated, showing that there is no economic harm, there is no economic waste, there's only increased production, increased revenue, and increased production taxes. Now, Mr. Savage asserts that that's just one token well. Well, it's not the case. We actually have a whole nother set of development in the Riddler, partly in the Riddler and then in the Robin, that was also immediately offsetting to the south. All that data will come out at the hearing. My intention here was not to overwhelm the commission with merits, but simply to show the one simple case with the most production data showing, immediately offsetting, that they can't meet the very first element. So I understand the commission's concern about harm, irreparable harm, but that's the whole point of this hearing and the whole point of the elements and the whole point of requiring the applicant to come forward with actual evidence and actual showing. And we didn't see that today.
Okay, thank you. Thank you all.
Mr. Chair, so just want to follow up quick one. Mr.
Please.
Rankin, thank you. Mr. Rankin, so you're saying that Mr. Savage or Leslie Katerra has not shown the harm, but assuming the commission denied the stay and then Penyon goes ahead and drill all these wells, would that not be a harm to Katerra if the commission is to consider the de novo case or to grant the de novo hearing?
Let me put it this way, Dr. Ampoma. In many situations, there's going to be a party who wants their plan to be the one to be selected. Is it a harm to them that their plan wasn't chosen? Well, they probably feel badly about it and they want their plan to be the one that's being drilled. But unless they can show that there's actual waste or show that there's actual harm, then they just have to be the upset loser, right? I mean, because they haven't demonstrated that the evidence necessary to effect a stay. So the bottom line is that whenever there's a forced pooling, where there's a contested a party contesting, they're going to argue that there's harm because they lost. But the fact of losing itself isn't sufficient to justify a stay. The fact that they lost is not sufficient to justify a stay. They have to actually make a showing. So if the commission were to deny a stay, which would allow Permian to go forward and drill its wells, then Permian would do so at its own risk if in the end, the commission were, in the unlikely event, to overturn the division and issue an order granting Katerra the right to develop this acreage. It would be at Permian's own financial risk because they would be the ones to drill the well.
Commissioner, if I may just clarify some of that as a follow-up. So first of all, the OCC and the OCD, they don't have enforcement powers. So if they deny the stay and Permian goes out and drills, what would be the remedy? That would be a very difficult situation to determine what the remedy would be, and would end up going to district court and be tied up into all kinds of legal entanglements. But let's look at, what Mr. Rankin says about, asserting harm during the contested hearing and then losing. You have to look at the basis of the loss and to see if that was legitimate. So Kotera demonstrated and showed a lot of evidence, plenary evidence, that there's economic harm in the disparity of the total development cost, because $250 million of additional and unnecessary wells would not justify any negligible amounts that would be non-additive to the EUR. The EUR is pretty set in the Wolfbone pool. So what the OCD did is they basically, as a matter of law, they ignored all that evidence that we presented, because they said that economic waste is not to be considered. Differences, disparities in total development plan, $250 million difference is not to be considered. So they did not define that as economic waste. And that, as a matter of law, goes against the statutory definition of waste. Now, there's Supreme Court cases, and for example, Santa Fe Exploration, where the commission granted rights to a operator to drill a well and then to drill a second well without moving the rig off site and coming back. And that was objected to by another operator because they said they didn't have a right to drill that second well. The Supreme Court said the commission has to consider, is obligated to prevent waste. They didn't say economic waste, they said waste. And what they said was it would be extra cost to move the rig off the well and bring it back on. So it was justified to prevent waste on purely economic basis to allow the operator to drill subsequently and sequentially the second well. Now that is a pure, and that's in Santa Fe Exploration versus OCC. That is a pure matter of considering financial and economic waste to be waste under the statutory definition. And that is what the division completely disregarded. And that is the evidence that we're asking the OCC to consider anew, to consider de novo in this motion hearing.
Okay. Any further questions from commissioners?
Mr. Chair, one other, if you'll allow me.
Of course.
Just looking at 1915-423A, do both parties agree that the de novo was filed, the request for a de novo hearing was filed within 30 days from the time of the original hearing, or decision rather?
I have not heard any objections to that, and we counted out the days, and we see that we satisfied that rule.
I think, Commissioner Bloom, that I looked at it when they filed it and they were within the time frame. I'm sure I would have raised it at the time. I don't recall having gone through so many different things since that time, what my calculation was. But nevertheless, if it were not with timely, that would be jurisdictional, and at any time we would be able to raise it. So I don't know at the top of my head, but I'm sure I would have raised it if that were the case.
All right. Thank you both. Okay. Thank you, Mr. Chair. No further questions.
Okay. Well, in that case, looking at the time, should we ask everybody to come back at around, how much time do you guys want to reserve, commissioners? Would you like to reserve for deliberation? Do you think we can be back by 11:30, or should we ask people, or should we just give people the lunch hour and just have them come back after lunch? Or I see nodding from Commissioner Bloom there. Is 11:30 okay? 11:45? Dr. Mpoma, thoughts?
Yeah, I mean, 11:45 should be okay, but I don't know if if our council believe we can get this through by that time.
let's give it let's say 11:45. And if it turns out that we need longer than that, we'll just come back to the general session and let people know that they should go to lunch. How about that?
So this
Yeah,
is
Mr.
Zach
Chair.
Chandler. Some quick mechanics. I need a motion to go into closed session under 10:15(1)(h)(3). Can someone make a motion to go into closed session under 10:15(1)(h)(3)?
Mr. Chair, I move to go into closed session under 10:15(1)(h)(3), where we will only discuss matters related to this case.
And I need a second.
I
And
second.
then Sheila, can you call the roll, please?
Okay, Commissioner Bloom? Do you?
Yes.
Yes. Commissioner Mpoma?
Approved.
Okay, Chair?
Yes.
Okay.
And Sheila, is
leave
there going to be a breakout session or how do we do it computer wise? Do you know?
Yeah.
I can send out a separate Teams meeting.
We'll look for that in our emails then, or
Yes, right now.
yeah. Okay. All right. Thank you. Please enjoy your coffee breaks, everybody.
Thank you.
All right, looks like our commissioners are all here. Sheila and Mr. Chandler, is everybody ready for us to be gavelled back in and our reporter?
Yes, we're ready in
Okay.
Douglas Hall.
Okay, great. Okay. The commissioners and I deliberated, so we'll talk about our decision in the matter of the stay. Just let me pull up my everything I need here for in a second.
While
And
while you're doing that, can you just state for the record that only the matters discussed in the closed session were those listed in the motion? Can you confirm that?
yes,
Thank you.
yes, I can confirm that. Yes, we discussed only the Coterra case in the closed session. Give me a second here. I'll give a brief, just oral record here, and the commissioners, please feel free to jump in and add whatever you feel is necessary. But after reviewing the papers that were submitted in this motion for stay and hearing the arguments of counsel, as well as having the responses to the questions from the commissioners, we walked through the 4 factors for under Tenneco, and we find the commissioners found that that there was sufficient showing under all 4 factors to support the granting of a stay pending de novo hearing of this matter. Is there anything else you'd like to read on the record, Commissioner Mpoma or Commissioner Bloom?
Mr. Chair, not from my side. Thank you.
No, Mr. Chair, thank you.
Great. Okay, we will ask Commission Counsel to finalize a order, and we will issue that forthwith.
So just for the record, if you could make a motion granting the order to stay with a second and a vote, that'd be great.
Of course, commissioners.
Mr. Chair, I move to grant the motion to stay.
Mr. Chair, I second.
Thank you. Did you want a roll call vote, or is no objections good enough?
This one you can do oral vote.
Okay. Any objections?
No.
No objections, so moved. Stay is granted. Okay, now if I could have the parties let's talk about setting this for a hearing. Given that there is a stay, we would like to minimize the delays in this matter and would like to set it as quickly as possible. The commissioners currently have a meeting set for August 14th. Our July dates are already full, but we have a August 14th date, and the commission is able to offer and set this for August 13th and 14th. Is that, I'd like to hear from the parties as to whether that will be viable for the parties.
Mr. Chair, so I talked to my client prior to this hearing, and they said that they have witnessed problems because it's a summer, July and August, and September would be the earliest date we could get everybody together. I apologize for that. I don't know how to get around that. I can inquire again and tell them about the August 14th date and see if we can figure out a way to get folks arranged around that date.
Mr. Rankin, you're muted.
Thank you, Commissioner Chair Chang and Commissioners. Permian Resources would strongly prefer to be able to go forward in August. However, I can save a fight over that because I'm going to be out, and my co-counsel has a conflict on that date, around those dates, and is unable to manage a contested hearing the week of August 14th. So, however, looking at the next availability, I understand from Ms. Apodaca that September potentially could work for the commission. I have confirmed with my witnesses that the September would work. I do believe we should be able to get this done in 2 days. So my request would be to set this at the earliest opportunity in September. And if a special hearing is something the commission would be entertained, I'm open for that as well. The only date in September that doesn't work for my witnesses is September 10th. And otherwise, in and around the regular scheduled meeting would work for Permian Resources. And we're eager to get this case heard and presented to the commission. Appreciate it.
Okay, commissioners, I understand for Dr. Mpoma, once the school year starts, that is, the calendar can get challenging. September, I mean, we currently have a regular meeting set for this, for the 18th. I would be able to make myself available the 17th and the 18th. I don't know about the other two commissioners. If the 10th is not available, I would be available too if the 10th and 11th is workable for everybody else. The 3rd or the 4th of September is also viable. What are your schedules like, commissioners?
Mr. Chair, so if we can do 18th and 19th of September, that works pretty well for me. You know, I do teach
Okay.
Monday and Wednesdays, so
18th. Okay,
18th and 19th, yeah.
I see. Commissioner Bloom?
Let me get to the 18th and 19th. If I'm not able to attend those days, I would have the land office appoint an oil and gas engineer to hear the case. So I think it's my short way of saying we can make that work.
Okay. Any objections from the parties to the setting this for the 18th and the 19th?
No, Mr. Chair, that should work for us. I should be able to make that work. There's another option that the commission might want to consider that could actually expedite some of the proceedings. Now, the de novo hearing is a right that Katerra is granted when they apply for it under the statute. But it's been clear that there are unresolved matters of law that have yet to be reviewed and determined. And it looks like that those matters of law would be dispositive about which development plan could be selected under the law. So if one of the plans is invalid, legally invalid or illegal, then that would be dispositive for excluding that plan. The other one would have to be accepted. So I would propose, if it pleases the commission and they grant leave, that it would be useful to have a motion to address the matters of law to see where the commission comes down on it.
May I respond?
Of course.
Commission members, Director Chang, I think that any legal issues can be properly addressed at the close of the hearing. There are contested facts that need to be resolved, and the council can address the legal issues in the context of those disputed factual issues and should be done at the close of the hearing. So I don't dispute that there are legal issues. However, I don't think it's worth the party's time to spin on, or for the commission to have to spin through additional legal issues that potentially may no longer be of concern, depending on how the facts are presented and the findings of the commission at the hearing. So I would ask that the commission direct the parties to instead brief any legal issues at the close of the hearing.
Mr. Chair, I would.
Well, could I ask a question of you, Mr. Of Katerra? Tell me if I'm wrong, but what I'm hearing is that you wish to propose filing a motion for partial summary judgment or summary judgment.
It would be similar to that. Now, under the rules of the division and the cases and the case law, there is a form of summary judgment, a type of summary judgment that can be reviewed. Now, if that's dispositive, then it would be a complete waste of administrative resources to go through a full-blown administrative hearing when you can't even select a particular development plan that was presented because it violated the law. We can find that out prior to, long before the hearing, and the commissioners would not be burdened with, additional administrative duties.
I understand your argument. Let's go to Commissioner Bloom, and then I'd have a question for our commission counsel.
Yeah, Mr. Chair, thank you. Mr. Savage, could you tell us, briefly in a minute or two, what the dispositive issues are?
Yes, sir. Thank you. The biggest dispositive issue is the taking issue. That is completely prohibited under fundamental principles of oil and gas law. It's completely prohibited under commission regulation, conservation regulations. Once you decide that, as a matter of law, which plan is the feasible plan. And then the other issue, maybe not as quite as dispositive. I mean, the taking is truly dispositive. The other issue that is bears strongly on this case is the question about whether or not the statutory definition of waste under the Oil and Gas Act includes economic waste, because that has been an unresolved legal issue that has come up in numerous division hearings, and the division will use it in certain ways, in one way, during hearings, and then they will use it a different way. So it would be really helpful if the commission could confirm that economic waste is in fact part of the definition of waste. And I think that would be strongly dispositive, maybe not absolutely dispositive, but strongly dispositive. if there's such a thing on the case.
Yeah. Mr. Savage, so you're imagining that both parties come in with the same plan that they had before, and that Permian wouldn't make any changes during the de novo hearing?
So Permian's plan is premised on there being at least one well in the Upper Wolf Camp, and that's what they show with the Batman development plan. One well, and even with one well, if they decide to drill less than the 4, less than the 8, 4 per section, 8 per both, all 4 sections, if they drill even less, which I assume they wouldn't, because today we've heard that their whole plan is premised on getting a deeper Upper Wolfcamp well. Even one well would violate the takings under the facts. So it would be dispositive. The only way they could come in and deny that they're not doing a taking, if taking applies, would be to come in and say they're just drilling just the 3rd Bone Spring, or they're just drilling the Upper Wolfcamp, and or they could do both, but they have to come in and say they're doing an allocation formula, and their plan precludes an allocation formula by law, because they've argued already on the record that they cannot violate the pooling statute based on surface acres. So they've already established the legal premise of their development plan on the record. So, I guess if they could come in and they could say, no, we're going to do an allocation formula now, then you would have a fair foundation for a hearing on the merits. But if they're not willing to say that they're going to do an allocation formula, then you got a binary decision between 2 very different legal interpretations.
Mm-hmm. Thank you, Mr. Savage. Mr. Chair, I think those are all things that could be dealt with, and perhaps properly should be dealt with in the de novo hearing, based on what we would learn from both parties. So that's where I'm at. Thank you.
Okay. Did you want to add something real briefly, Mr. Rankin, before I turn to Commission Counsel?
Thank you. I would. If you look at the exhibits that we presented, the question about taking that Mr. Savage says is dispositive against Permian Resources is equally applicable to Coterra, because they're going to be pulling substantial volumes from the wolf camp. So to say that it's a one-way street is nonsense. That's why it's important first to hear the evidence, and then subsequent to the evidence presentation, the parties can articulate how the legal principles apply and support their case and their ultimate approval. So I don't think that there's any need for the parties or council to spend time or money, resources, or the commission's valuable time and resources reviewing briefing before we actually get the facts on the table.
Turning to commission counsel here. While certainly I appreciate that everybody wants to be as efficient with time and avoid unnecessary briefings and unnecessary procedures, does the commission, if one of the parties wishes to file for summary judgment or partial summary judgment, what is the commission's power to decline to hear that, I guess, or decline? Does the commission even have the power to decline to take that up?
So, Mr. Chair, I'm sure there's a section about pre-hearing motions and things of that matter. So parties are free to file whatever documents they want. I think that I have not heard sufficient information that the law can be separated from the facts. So I think Commissioner Bloom's response that it's 2 days and one side gets 1 day, the other side gets the other day. They can use their time however they want. If they want to spend it all on legal argument, if they want to have 3 witnesses. But after spending a morning listening to the information, I have not been able to have Mr. Savage stop himself from intertwining facts into his legal argument. So I have not been persuaded that there is a dispositive legal issue. But again, he is free to file papers pursuant to the adjudicatory rules.
Okay. I think I'm going to leave it there because I think the parties are free to file papers that the rules allow them to file. But that we are going to go ahead and set September dates, and at least hold that in the calendar so that they can be set for hearing. And then it will be amongst the parties if they can agree not to relitigate this 20 times over and to keep it all on the 18th and the 19th. I trust that counsel between the parties will be able to figure out what is most efficient for everyone involved. I will just caution the parties that because we are setting it for a Thursday and a Friday, there will not be a option to extend if things run long. So I urge both parties to try to keep things as brief and as concise and as to the point as possible, and to think about how best to present their case given those time constraints so that we don't run over. In that case, sounds like we are all agreed to at least hold the 18th and the 19th or to set this matter for the 18th and 19th of September. If so, I would entertain a motion.
Mr. Chair, I so move.
Mr. Chair, second.
Any objection? Without objection, so ordered. Okay. Looks like we've already run into lunch, so I would entertain a motion to break for lunch and come back at 1 p.m. and continue the agenda for today's meeting at 1 p.m.
So, Mr. Chair, the next item will be like 3 minutes. So if I could beg your indulgence to do the next one.
Sure, we can do that. In that case, I call case number 24594.
Good afternoon now, Mr. Chair and Commissioners. Dana Hardy with Hardy McLean on behalf of Targa Midstream.
Thank
Good
you.
morning, Mr. Chair, and welcome. And to the commissioners. My name is Jesse Tremaine. I represent the Oil Conservation Division.
Thank you.
Would you like us
Mr.
to proceed or?
Yeah, I believe so, Mr. Chandler, unless you have, unless you advise otherwise, may the parties proceed?
Yes, they may.
Go ahead, please.
I'll take it from here initially, and then Ms. Hardy jump in as necessary. This was a case that was heard last summer. There was Ms. Hardy prepared a proposed order at the request of the commission. There was some substantial delay in getting updates to that. And then after further correspondence, I submitted in the updated version recently through the law clerk for approval by the commission. But based on the record of hearing and after review by OCD's technical staff and with minimal proposed edits to what was prepared by Ms. Hardy, I believe that the parties are in agreement on the form of the order and request that the commission adopt said order today.
And Mr. Chair, I agree with Mr. Tremaine. Both parties agree on the form of order and request that it be entered by the commission.
Okay. Looks like an unopposed request. Commissioners, did you have any discussion or questions?
No, Mr. Chair.
Okay.
No, Mr. Chair.
In that case, I would entertain a motion to, I guess, to adopt the final order of the commission.
Mr. Chair, I would so move.
Mr. Chair, I second.
Before taking a vote, I'm just going to confirm with Commission Counsel. Do you need a roll call or voice vote good enough?
The roll call was only specific to going into closed session. Everything else you can do roll call.
All right. You mean, okay. Well, any opposition? Hearing none, so ordered. Congratulations, parties.
Thank you, and thank you for your time. We appreciate it.
No problem.
Good afternoon.
Go ahead.
I apologize. I'm here for the third matter. My name is Abby Lubbock. I'm here on behalf of Silverback Operating. This commission has already suggested that we continue the case, so I don't know if you'd like to discuss that matter now or later. So I apologize for interrupting, but
I was just going to ask the commissioners if you guys are fine working a little bit into lunch hour here. I see some nods and I don't see vigorous opposition. So let's go ahead. In that case, I will call case number 25237. I will turn it over to the I will turn it over to all the parties, all the various councils of record. If you could keep your opening comments on this brief, 5 minutes, please. No more. Unless Commission Counsel, you wanted to jump in?
I do not want to jump in. I'm waiting for the parties to appear and then make their statement.
of course, my name is Abby Lubbock. I'm here on behalf of Ben Holiday and Silverback Operating. I just wanted to say at this time, we have no objection to any sort of continuance in this matter.
Great, thank you. Is the
Jonathan-
applicant?
Jonathan Samaniego, representative of American Energy Resources.
Okay. Go ahead.
Good morning. This is Jesse Tremaine, representing the Oil Conservation Division.
Okay, and I object to the motion to continue. American has complied with the rules and the division orders. I believe that it needs to be handled today.
From what I understand, I apologize. Go ahead.
That's okay, go ahead.
From what I understand, in accordance with subsection A of 1915-413 of the NMAC, any sort of pre-hearing statements must be received at least 4 business days in advance, but in no event later than 5 p.m. Mountain Time on Thursday preceding the scheduled hearing date. Unfortunately, we did receive that statement from the opposing party last night, I think around 6 p.m. So that's kind of where we stand. We understand that these prerequisites are necessary to these hearings. So we would just like to be in compliance with those rules, just so y'all can, determine the matter and be, again, us being compliant.
Great, thanks. I will turn this over to Commission Counsel. Commission Counsel, was there a, there is, the Commission Counsel, could you advise us on whether or not the parties are properly situated to proceed, having filed papers on time or not?
No parties filed papers on time, whether that was by choice or not, but it is what it is. So that's a mandatory requirement. There was paper that was filed, but it was untimely, and it also did not include all the required elements. I'm sure the commission could proceed and have oral arguments, but it would probably lead to a district court case. So probably the cleanest way to do it is just to postpone until the parties have sufficient time to follow the rules. That way there isn't a decision where a court feels like it's a decision made on form rather than substance. So my advice to you would be actually, and I'm looking for the exact verb. Under Rule 1915-415, I would recommend the commission continue this hearing until its next regularly scheduled meeting.
Give me that. Could I have that citation again, please?
Yes, 1915-415.
Okay. Reviewing the record, commissioners, unless the other two commissioners saw something that I didn't, I don't believe we got timely and thorough sufficient records from any of the parties. So we are not in a position to be able to proceed, because it appears to me that the parties have not fulfilled their burdens under the rules. So I would.
I object. I object for American, and on the grounds and merit is that I was provided by the OCC clerk to be able to provide the documents that same day. I got an email requesting both parties to file the statements the same day. They were filed. I filed them before 5 o'clock, the ending of the day. I also sent them to Mr. Ben Holiday before the end of the day at 5. There was sufficient time for all parties to act within division orders.
Commission Counsel, will you please read the rule again and advise us on what the deadline was? Wasn't it 4 days ago?
Mr. Chair, 1915-413 B1 Mexico Administrative Code. A party to an adjudicatory proceeding who intends to present evidence at a hearing shall file a pre-hearing statement, serve copies on other parties or for parties that are represented at least 4 business days in advance of the scheduled hearing before the division or the commission, but in no event later than 5 p.m. Mountain Time on the Thursday preceding the scheduled hearing date. The statement shall include the names of the party and the party's attorney and concise statement of the case, names of witnesses the party will call to testify at the hearing, and in the case of expert witnesses, their fields of expertise, the approximate time the party will need to present the case, and identification of any procedural matters that are to be resolved prior to the hearing.
So if you could help us, does that mean in order to be timely, all of the documents would need to have been filed by 5 p.m. on June 17th?
That's correct.
Okay, is there any factual dispute that the documents were filed by 5 p.m. on June 17th?
Mr. Chair, there's no factual dispute. There's computer timestamps.
Right. Okay. So unfortunately, in order to preserve your right to have this hearing at all, or to preserve American Energy Resources' right to have a hearing at all, the best that we can do for you, Mr. Samaniego,